Hello everyone. In this video, we are going to discuss Unit 2 of the Sale of Goods Act, which is conditions and warranties. Now, first, conditions, they are stipulations. Stipulations means agreements. They are the foundation of the contract, the basis of the contract, the basis on which the contract is made. And it is important for the seller to fulfill these conditions. And if he fails to do so, the buyer can cancel the contract and he can also claim the damages. When we talk about conditions, conditions may be express or implied. Express is something which the parties agree, and what they agree could be anything. So it's obviously not feasible for us to study what is express conditions. So what we are actually going to study here is implied conditions and implied warranties. What is warranties? They are stipulations which run collateral. So they are not the main purpose of the contract. They are not the foundation of the contract. They are not the reason the contract is made, but they are subordinate or run parallel to the main contract, right? They are subordinate to the main contract. So since they are not essential, if there is a breach, you cannot cancel the contract, but you can only claim the damages. You cannot cancel the contract, but you can only claim the damages. Now, what are the conditions? The first one, condition as to title. When the seller is selling the goods, we assume that he has a right to sell the goods. So if he is selling the goods on which he has no rights, and the buyer is deprived of the goods by the true owner, the buyer can claim the price from the seller. Deprived of the goods means the true owner takes away the goods from the buyer. He can claim the price from the seller. Second, sale by sample. When the sale is made by sample, that means I show you the sample. If you like, you can purchase the goods. When the sale is made by sample, the bulk of the goods must correspond to the sample. Second, the buyer must be given an opportunity to examine the goods. That means he's not bound to accept the goods without even checking them. He has to be given a right to examine the goods, and the goods must not have any defect which makes them unmerchantable. That means these defects are not visible to the eye. They are latent or hidden defects, but they make the goods unmerchantable. Next is sale by description. What is next one? Sale by description. The word description has not been defined. So if you say description, description could be anything. It could be the place where the goods are grown, the color of the goods, it could be the type of the material, it could be the type of packing. Anything can form a part of description. Law has not defined the term. When the sale is made by description, the bulk must correspond to the description. If the goods do not correspond to the description, can the buyer reject the goods? Yes. The next one is sale by sample as well as description. When the goods are sold by sample as well as description, so basically, sample is I'm only showing you the sample. Description is I'm only describing the goods to you. Sample and description is the buyer is showing you the sample as well as giving you the description. When the goods are sold by sample as well as description, the bulk must correspond to the description and the sample must be described as it is known in the market. So if I have a generic name for the goods, I have a particular name for the goods, I cannot use any other name for the same goods. So when the description is given, it must be as it is known in the market. The next one is specific purpose of the buyer. When the buyer specifies the reason of his purchase to the seller, he depends upon the seller's skill and judgment, and seller deals in those type of goods. Then it is the duty of the seller to supply the goods, only those goods which suit the buyer's purpose. If he supplies the goods which do not suit the buyer's purpose, can the buyer return the goods back? Yes, the buyer can return the goods back. Now, how will I identify whether it is description or purpose? The seller says to the buyer, I will sell you rice grown in Chhattisgarh. This is description. The buyer tells the seller, I want to purchase goods from you. Rice which is grown in Chhattisgarh. This is what? Description. The buyer tells the seller, I want rice grains which are this long. This is description. The buyer says, I want rice grains this long to make biryani. This is specific purpose of the buyer. When I just describe the type of goods I want, that's description. But when I tell the seller why I want those goods, it is sale for the specific purpose of the buyer. I hope this kind of gives you, because this clarity is not there. Many a times you get confused. I hope this gives you that clarity. The next one is sale by. The next one is sale by condition as to usage of trade. Now there are some products which are supposed to be used for a particular purpose. I don't have to tell you why I want that. Do I have to say I want a pen for writing? a pen is supposed to write. They give you a pen, sir. This is only for show to hang. You cannot use this pen to write. Do you fulfill the condition? No. So by usage, we know the purpose of the product. If the goods do not suit that purpose, can I return the goods back? Yes. So custom or usage of trade. Remember the umbrella, under my umbrella, right? The next one, sale by goods condition as to merchantability. Whenever I purchase the goods must be suitable for the purpose that they are used. If the goods are not suitable for the purpose that they are used, can the buyer return the goods back? Yes. When the sale is made by description and the buyer is a dealer in those type of goods, it is implied that the goods must be in a usable state. If they are not in a usable state, can you return the goods back? Yes. Condition as to merchantability. Merchantability includes defective packing of the goods. Merchantability also includes, what do you say, if the goods like I'm sorry, defective packing of the goods, but it does not include personal ailment. So if you are allergic to goods, you cannot claim any damages there, or you cannot return the goods. The next one, condition as to wholesomeness. This is an extension of merchantability. In case of food, in case of food or provisions, apart from being merchantable, they should be wholesome. That is, they should be in a consumable state. If the goods are not in a consumable state, you can return the goods back. The next one is warranty. When I say warranty, they run collateral. So they are not the main purpose of the contract, but they run collateral to the main contract. And if there is a breach of warranty, you cannot cancel the contract, but you can claim the damages. The first warranty is nothing but condition as to title. In condition as to title, you must have claimed the whole price. But instead of claiming the whole price, you only claim the damages. You have treated a breach of condition as a breach of warranty. It was a breach of condition as to title. You should have claimed the whole price. But instead of claiming the whole price, you only claim the damages. You have treated a breach of condition as a breach of warranty. The second one, warranty as to freedom from encumbrances. Encumbrance means charge of a third party. Encumbrance means charge of a third party. When you sell goods on which a third party has a charge, and because of this charge, the buyer suffers damages, the buyer can claim those damages from the seller. If let's say you have pledged the goods to someone and the third party has a special right over the goods, and because of this, the buyer suffers any damage, buyer can claim those damages from the seller. If the goods are of a dangerous nature, it is the duty of the buyer to inform it is the duty of the seller to inform the buyer about the dangerous nature. If you fail to inform the dangerous nature, it can be done on the packing or by word of mouth. If you fail to inform the buyer about the dangerous nature and the buyer suffers damages, the buyer can claim those damages from the seller. The last one, quality as to fitness. So in this umbrella case, as we were talking about umbrella, let's say you have the umbrella does not suit your purpose. That is, it does not protect you from the rain. You get completely drenched. So you decide to return. You decide not to return the umbrella, but you decide only to claim the damages. So this is again a breach of condition treated as a breach of warranty. Ma'am, if I get in the exam, what am I supposed to write? You will write, I have a right to claim the damages. In case they mention he claimed the, sorry, you will write, I have a right to claim the price. In case they mention in the question he claimed the damages, then you will write about warranty. The last topic of this unit, caveat emptor. It is the buyer's responsibility to check and select the goods as per his need. If the buyer selects the goods on which if the buyer is making a wrong selection of the goods, he cannot hold the seller responsible. I repeat again, it is the buyer's duty to check whether the goods that he's buying suits his purpose or not. If the goods are not suitable to him, he cannot claim anything from the seller. That means if the buyer has made a wrong selection of the goods, he cannot return the goods back. But if the sale is made by description, the goods are not as per the description. If the sale is made by sample, goods are not as per the sample. Goods are not merchantable, goods are not wholesome. Can you return the goods back? Yes. So in all the implied conditions, the rule of caveat emptor does not apply. Right? With this, we are done with Unit 2. In the next video, I'll see you with Unit 3. Till then, happy learning and stay motivated. Thank you so much.